Now that the amendment has been adopted, I'd like to just talk a little bit about the changes to the underlying bill. And first and foremost, I would just simply ask, the bill that we passed out of committee is amended by several changes, and I'm just wondering the reason why those changes were created, first off.
Thank you, Senator Sampson. Senator Kushner, who's care to respond?
Thank you, Mr. President. Through you, as is often happens in the legislative process, through discussions with advocates, with members of the legislature, and with the executive branch, we come to some agreements on what we think works best. And so the modifications that you see here today have been worked through with taking into account a large number of voices and opinions. And I feel very secure that this makes the bill a better bill and one that we can pass. Through you, Mr. President.
Thank you, Senator Kushner. Senator Sampson.
Thank you very much, Mr. President. And I appreciate that answer. And I do agree. The amendment does improve the bill from the underlying bill that was before us. And simply it's because it limits the impact of what is a mandate on the employers of the state of Connecticut. I've never been a fan of the paid sick days policy coming from the state as a mandate, personally. Certainly many employers do offer benefits to their employees, but they do that voluntarily, and they do that as a matter of negotiation and as to create a competitive edge, I guess, when they're in the business of recruiting people to work for their companies. And I think when we engage in activity like creating a mandate on employers that they must provide a benefit to their employees, we are effectively damaging the freedom of the parties to be able to negotiate those terms themselves, especially if they may not even be interested in what we have to offer as a policy decision as the state of Connecticut. You may have an employee who says, no, I really don't want the paid sick days policy. I would much rather ask my employer for a smaller increase in the weekly pay, for example. But because this mandate exists, we are limiting the ability of both the employer and the employee to be able to negotiate what is best for them. And as I've mentioned many times in this circle, we cannot create things out of thin air. There is no free lunch, and there are certainly no free mandates. When we tell a business that they have to provide something, that also means that they are going to take that into account when they make determinations about other benefits they offer or how much they pay their employees, etc. So I've never been a fan of the underlying policy. But we should really get into the changes here and talk about just what is in fact changing. So I'd like to go through the bill, not in tremendous detail, but just so that we have a full understanding of what exactly is happening. The very first section has to do with definitions. And I think this is where we also see the first real significant change. It doesn't really happen until the second section, but we notice that we start to change where it says service worker in the bill in a number of places to now say employee. And we will get to that in a moment, but that tells us that this bill is going to expand the scope of who is covered by it. But in Section 1, I would just ask on lines 18 through 25, and then again in lines 39 through 44, there are references to collective bargaining agreements. I'm wondering if the good chairwoman of the Labor Committee can tell me what the reference here is intended to do. Through you, Mr. President.
Thank you, Senator Sampson. Senator Kushner, would you care to respond?
Thank you, Mr. President. Through you, this part of the bill that is referenced and those lines would recognize that in multi-employer health plans in the construction trades, there is an approach to benefits that's different in other industries. And so it would recognize that, and it would allow those agreements to go forward and provide the benefits as they have done in the past. Through you, Mr. President.
Thank you, Senator Kushner. Senator Sampson.
Thank you, Mr. President. I will just translate for those who were listening that what is going on in these paragraphs is effectively making any employers and employees that are covered by collective bargaining exempt from the policy before us. It's something that I've taken issue with many, many times in this chamber and in the House chamber, that we often make policy for other entities, but we find ways to exclude the state, or we exclude folks we're trying to protect from our policy. And I just find that ironic that if we think that something is such a good policy that we wouldn't want it to apply to all people. And certainly, I respect the notion of collective bargaining and that those agreements should, in fact, supersede this state policy. The question is, shouldn't a agreement between a single employer and single employee trump this policy as well? And that's where I would come from on this debate. And you'll hear me refer back to that ideological difference between us and the proponents of this bill over and over throughout this conversation. If we move on to, well, actually, maybe it's probably worth touching on, because I think the amendment does, in fact, change the definition of relatives. I know the amendment on line 46, it says the language "in an individual related to" is stricken, and then the words "family member" is redefined. I'm wondering if the chairwoman would tell us exactly what the change is from the current law to the amended bill before us. Through you, Mr. President.
Thank you, Senator Sampson. Senator Kushner.
Thank you, Mr. President. Through you, we have expanded the definition of family here to match and mirror what we have established in our more recent legislation regarding time off from work related to family illness. And that would be found in the Paid Family Medical Leave Act that we passed in 2019, with an understanding that we're expanding the definition of family to be more inclusive of relationships that are akin to a grandparent, a parent, sibling, so that we are capturing the reality of family relationship today in the United States. Through you, Mr. President.
Thank you, Senator Kushner. Senator Sampson.
Thank you, Mr. President. I appreciate that answer. I noticed that in the amendment, family member now no longer will include aunt, uncle, niece, nephew, or cousin. And I'm just curious why that change is being made. Through you, Mr. President.
Thank you, Senator Sampson. Senator Kushner, can I respond?
Thank you, Mr. President. Well, that family member inclusion is in the Paid Family Medical Leave Act. That's a different type of serious illness. And we came to an agreement that it would be harder to it might be harder to establish those relationships for a very short-term illness. So when we are, so that does vary from what we have under the Paid Family Medical Leave Act by carving out the aunt, uncle, niece, nephew, or cousin. Through you, Mr. President.
Thank you, Senator Kushner. Senator Sampson.
Thank you very much, Mr. President. I'm wondering if a aunt, uncle, niece, nephew, or cousin could still be covered if their relationship with the employee in question was similar to that of someone who is a sibling or a parent, something like that. I know that there has been language in other bills where we have considered certain types of relationships to be akin to a family relationship, even if they are not technically so. Is that the case in this bill? Through you, Mr. President.
Thank you, Senator Sampson. Senator Kushner, can I respond?
Through you, Mr. President, if in fact the person's relationship, if the person happened to be an aunt or uncle and their relationship to a child, for instance, was that of parent, that they raised that person, that child that was sick, then in fact, yes, they could be considered in a family relationship in loco parentis when the individual was a child. Through you, Mr. President.
Thank you, Senator Kushner. Senator Sampson.
Thank you very much, Mr. President. I appreciate that answer. And while you were speaking, I did discover that in lines 54 through 58. And that's perfectly understood. I want to get to really the meat of the bill, which begins in Section 2, which effectively is where the real policy takes place. It says, each employer shall provide paid sick leave annually to each of such employers employees in the state is the new language versus service workers. Can the good chairwoman explain to me what kind of expansion is this? Who were the service workers that were covered, and how does that differ from employees? Through you, Mr. President.
Thank you, Senator Sampson. Senator Kushner, care to respond?
Thank you, Mr. President. The previous definition of service worker can be found in the underlying statute. Those lines have been stricken now, starting on page 67, but it was very specific to certain classifications that are understood and classified by federal guidelines, the Bureau of National Statistics, as service workers, and it's specified in the lines that now would be removed to expand it to include all workers. Through you, Mr. President.
Thank you, Senator Kushner. Senator Sampson.
Thank you, Mr. President, and I appreciate that answer. Looking at the bill, the section that just defines service worker back in Section 1 is a pretty lengthy section that covers many, many different types of jobs, ranging from food service managers to physician assistants to someone who is a host or hostess in a coffee shop, ticket takers, and so on. There's a great many people included in this list, but I'm just curious, for example, who wasn't included in this list that will now be captured? Can you give us a few examples through you, Mr. President?
Thank you, Senator Sampson. Senator Kushner, care to respond?
Thank you, Mr. President. This will now include all workers who fall under, who are employed by an employer in the state. Previously, you can see there were some exemptions, starting on line 109, computer proofreaders, copy markers, statistical assistants. So there were a number of people that were excluded under the previous statute that now would be included. Through you, Mr. President.
Thank you, Senator Kushner. Senator Sampson.
Thank you, Mr. President. I appreciate that answer. This is a very, very important piece of legislation that we are debating before us. And I will tell you that I have struggled reading through some of this language because it's very difficult to think about all of the different ways people will be impacted. And to me, that was the first real significant question, to say, well, just how much of an expansion is this? We've got quite a few different types of job descriptions already indicated and already covered under the current law. But changing that to all employees, I think, is intended to be a very, very significant expansion of coverage. I don't really know how many people that would cover. Do we know how many people are currently covered by the paid sick days policy that exists in the state of Connecticut versus how many might become covered if this passes today and becomes law after going through the House? Through you, Mr. President.
Thank you, Senator Sampson. Senator Kushner, care to respond?
Through you, Mr. President, I don't have that information.
Thank you, Senator Kushner. Senator Sampson.
Thank you, Mr. President, and I appreciate the honesty from the chairman. To me, it's an important bit of information that we should really know. What we are doing here with this policy is we are telling businesses that don't work for the state of Connecticut, in fact, necessarily so in this particular piece of legislation, that they must adopt a policy that costs them money, whether they like to or not. Now, many employers already offer paid sick days of their own free will and accord and what they've negotiated with their employees. But here, we're telling them that they don't have any choice, but they have to, which does quite a few things differently than I think people in America have traditionally felt the government's role to be. First and foremost, as I mentioned, it takes away the ability for a negotiation to take place between an employer and an employee to determine what benefits both of them feel comfortable with by inserting the state government to decide, well, this is the benefit that you're going to have and you're going to offer, whether that's something that they agree with or not, which I think is a violation of the individual rights and liberty of both of those parties. And that's like the first significant concern I have about this type of legislation altogether. But it also locks them into something so that down the road, if they want to change that negotiation from paid sick days to something else, or come up with an alternative, they may not be able to because they've got to comply with this law mandating their behavior, even though there's no compelling interest that the state has to engage in this activity. This is just activism, effectively, on behalf of people in the legislature who seem to think that they know how to run people's businesses better than them. And I reject that on its face. And to expand it significantly, I think is clear evidence that that was what was intended all along. And that's how these things happen. Let's require folks to offer paid sick days coverage, but we'll do it in a very quiet and really insignificant way in cases where many people probably already offer and receive this benefit, and few people will notice. But what happens is, inevitably, once that is accepted, the legislature then finds a way. The folks who have a more progressive view find a way to go ahead and expand that further and further. And we see policies like this grow incrementally over time. And I always try and make a warning. And I don't recall debating paid sick days. It happened right about the time that I think I was first elected. So I don't know that I certainly wasn't in the Labor Committee. But I may have mentioned something if I was around at the time. But I've debated so many similar policies over the years, and the same thing seems to happen here. One of the most significant changes that might affect the numbers I was just asking for, and I would remind everyone, that's information that would have been critical to me, and I think should have been critical to the majority before bringing this policy forward. How many people are affected by this? I mean, to me, that's like the most basic question. That's like the first thing we should be asking. It shouldn't be like, I'm sorry, I don't have that information. That is not acceptable. If you're going to pass a mandate that changes and alters the behavior of employers and employees in this state, that has a direct impact on the future economic viability of Connecticut, the creation of jobs, and the growth of an economy, you should have an answer to a basic question like, how many people are affected by this? One of the things that's going to affect them more than anything is not just the classification going from service workers specifically, as enumerated in Section 1 of this bill, to all employees, but it also changes it from employers that used to, under current law, only be affected if they had more than 50 employees. This bill now affects any employer that has at least one employee. Can I ask through you, Mr. President, how many more businesses are affected by this policy change going from more than one employee versus the current law, which is more than 50 employees? Through you, Mr. President.
Thank you, Senator Sampson. Yes, you may ask. Senator Kushner, care to respond?
Thank you, Mr. President, and I can answer that question. About 12% of the workforce in Connecticut was previously covered, so this would approximately bring in more than 1 million workers that previously were not covered. I was not in the legislature, or even close to being in the legislature, when this bill first passed. There haven't been adjustments to this law since it was passed more than a decade ago, roughly 12 years ago, I believe, when we enacted this. So just to, it wasn't a specific question, but I know it was part of your remarks, and I thought it might be helpful to add that to the conversation. Through you, Mr. President.
Thank you, Senator Kushner. Senator Sampson, sorry about that.
Thank you very much, Mr. President. I appreciate that answer. Yeah, I was first elected in 2010. I remember the paid sick days legislation. I just don't remember whether I actively engaged in the debate in the House at the time. I certainly remember voting against it. That much I can remember. And thank you very much for the information. And that is valuable. It doesn't really answer my question as far as the number of businesses or the number of employees, but we at least have an understanding of just what the scope is. It used to be the current law, well, not used to be, the current law, 12% of the state's employees are covered by this policy. And presumably it's going to go to some number close to 100%, because there are still going to be some certain exemptions, not to mention the collectively bargained employees throughout the state. So you're talking about a pretty significant change in a current law, and not just a law that impacts people in an insignificant way, this has the effect of possibly creating a very significant impact on small businesses in particular. And I can't stress enough just how critical the change is. I think that most major companies that have over 50 employees, and I'm not suggesting this is a good policy to mandate on them either. I think it's the exact opposite of that. I would never suggest that they do it. But the thing is that most of these companies that have over 50 employees probably are offering significant other types of benefits, health care, paid time off, sick leave, who knows. I think that they do that already in many, many cases. And I think there's a lot of other businesses that might want to offer those types of benefits to their employees, to be good employers, and also to compete with other employers to get the best employees out there. The thing is that when you're talking about very small employers, somebody who is, just expanding their business that was just them, a sole proprietor for a number of years, and they finally get around to the opportunity to bring on an employee, this is a burden on them. And we have so many other burdens on them already. And for me, one of the reasons why I came to this place, the reason why I ran for office, the reason why I'm here is because I want people to have an easier time to be able to pursue their passion in life, to be able to pursue their happiness, as our Declaration of Independence says. And that means to be able to start a business, to do what they want to do. And unfortunately, the state of Connecticut, the current majority, keeps putting more and more impediments in the way of that happening, slowing down the creation of that opportunity. Mr. President, would this sick leave bill apply to an employer that has one part-time employee? Through you, Mr. President.
Thank you, Senator Sampson. Senator Kushner, would you care to respond?
Thank you, Mr. President. That is the case. It would apply to part-time employees, even if it was one part-time employee. I do want to, normally I wouldn't do this, but because it was said twice, I just want to make sure the record is clear. The carve-out for the exemption for collectively bargained agreements is only in the construction trades, and that is because they have a very different way of paying out workers and paying benefits. So it isn't specific to all collective bargaining agreements throughout the state. It's specific to the construction trades. Through you, Mr. President.
Thank you, Senator Kushner. Senator Sampson.
Thank you very much, Mr. President. Well, your clarification requires a couple of other clarifications. The first one I would suggest is, and I love the fact that we can get into a little bit of a back and forth debate, which doesn't happen nearly as often as I'd like in this chamber, actually. I think we would be well served if we could get into a real conversation on some of these bills instead of someone saying their piece and another person saying their piece and never actually being able, not to argue, but to debate, to truly debate whether or not something is good policy. 2 points I would make, which is, number one, I think there are countless different types of businesses, employers in the state, in countless different types of industries, and I think they all have their own special ways of determining how they want to pay their employees, and there are countless different people in our state who are employed, who have countless different ways that they might want to be compensated. So I respect the point that we are carving out a certain small segment of the population to be exempt from this policy, which I will repeat makes no sense to me because we shouldn't be carving out anyone when we make laws. Laws should apply to everyone equally. But I would also argue that there are a great many other collectively bargained, particularly public sector employees. I believe we were discussing the impact on the change to the current law that would become a part of the policy for the state if this amended bill before us passes. And that is the change from applying to businesses as currently 50 employees or more to now being all businesses and all types of employees for businesses with as little as one employee. And we established moments ago that this, in fact, does also include part-time employees. And I think I was lamenting the idea that somebody who is, a new startup business, or someone who's, just getting around to expanding their solo one-man show kind of business into something bigger, is going to be in a less opportune position to do so with the passage of this bill. And it's not just this particular mandate on businesses. It is a collection of mandates on businesses that we have in the state of Connecticut. It's death by 1,000 cuts. Everyone knows that expression, and this is just another one of those. And I think it's a very significant one, because I think it is going to complicate things and make it more costly for someone to take that step. I'm in the real estate business, and I've thought many times about hiring a potential assistant or something on a part-time basis. And, the things that stop me are just how difficult it is to deal with the payroll aspect of things, and getting the money correct, and all of the requirements that you assume the second you go from being a one-person realtor to now having a staff. When you do that, lots of things change for you, and it makes it complicated and difficult to do so. And we shouldn't be in the way of that progress, Madam President, is my argument. And here we are finding new and clever ways to put more requirements on businesses. And as I mentioned, I think the underlying law that was passed a little over a decade ago was done with the full knowledge by the proponents that it wasn't going to impact all that many businesses. Certainly it was wrong then, and it's wrong now, but the difference was that at the time, they were impacting only a segment of the population, and only larger businesses with 50 or more employees. That is a far cry from where we are today debating this bill right now. I fear, Madam President, that there's going to be lots and lots of unintended consequences just with that one aspect of the bill. I can imagine that employers are going to try and find ways to work around this. They're going to switch people that work for them as employees to try and characterize them as independent contractors to avoid the benefits that are mandated to them. Maybe they even want to offer more gracious benefits to their employees, but they don't want to be told by the state of Connecticut what benefits they have to offer. Maybe there will be small businesses trying to get around this by paying people under the table, or paying people in a cash manner. I think that these things are truly going to happen as a result of this policy, and I don't know if those are unintended or intended consequences, because I think they're very obvious. Madam President, I think it's quite clear what will happen if this becomes the law in Connecticut. Let me get back to, one thing I know we were discussing before our mini break was the discussion about who's exempt and who's not. And I appreciate the good chairwoman of the Labor Committee getting up to talk to me about the fact that we're exempting collectively bargained folks in the construction trades. But I would point out that I think most public sector employees are probably already exempt, even though many of them have benefits that probably exceed this, simply based on the notion of supersedence, which is a crazy thing that if people listening aren't aware of, but it says that certain types of collective bargaining agreements that take place with public entities like towns and the state of Connecticut, they don't even have to follow the law. You can have a contract as long as it's with a public entity that ignores the law that every other person in the private sector has to follow. And I've always found that shocking, and I've tried over the years to eliminate supersedence in our statutes, unsuccessfully, of course, given the makeup of the legislature these days. But let me get back to Section 2, which is the key paragraph in this bill that lays out how it's all going to work. When, through you, Madam President, do new employees begin accruing benefits? And is that changing from the current law?
Senator Kushner.
Through you, Madam President, and it's good to see you up there today. Employees start accruing accruing their time off benefit from when they are first employed.
Senator Sampson.
Thank you, Madam President. Is that the same as the current law, or was there a waiting period under current law? Through you, Madam President.
Senator Kushner.
Through you, Madam President, there was not a waiting period for accrual of time under existing law, as there is not a waiting period to accrue the time in this bill.
Senator Sampson.
Thank you. And I noticed, but there's a date indicated here, October 1st, 2023, on line 136. Can the good chairwoman tell us what that means? Through you, Madam President.
Senator Kushner.
Through you, Madam President, that date change on line 136 refers to what the employee's rate of accrual will be upon first day of employment.
Senator Sampson.
Well, thank you, Madam President. I appreciate the answer, although I don't think you were really answering my question. I was asking about what October 1st, 2023 is. I will certainly get to the fact that employees begin accruing on their first date of employment, but I'm just curious as to know what that date on line 136 refers to. Through you, Madam President.
Senator Kushner.
Through you, Madam President, the underlying bill said beginning on January 1st, 2012, employees would begin to accrue, employees covered by the existing statute would begin to accrue their paid sick leave from their first date of employment. That has not changed, but in subsection 2 there, so it's section 2A2, the rate at which one earns that time off has changed, and therefore, but it only changes effective with employees beginning October 1, 2023. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. I'm assuming that that date is simply just a reference to the effective date of this entire policy, because I did go back to the beginning and noted that it does show that all of Section 1 is effective October 1st, and all of Section 2 is effective October 1st, and so on. I just thought it was odd that the date was indicated there as if folks were not accruing benefits currently, because I think they are occurring currently under current law. And as was already described by my colleague, they are accruing at the same rate, which is 1 hour of paid sick leave for 40 hours. And I'm realizing that I may have misspoke, and I would love a clarification if the chairwoman wants to explain. Through you, Madam President.
Senator Kushner.
Through you, Madam President, I apologize for giving you that nonverbal signal, but I did want to just maybe clarify that the accrual starts from, your question earlier was about when do people start accruing. They start accruing at the same time, but the rate of accrual has changed. So in other words, if someone had already accrued time leading up to October 1st, 2023 at the rate of 1 hour for every 40 hours worked, that is when the change takes place to be 1 hour for every 30 hours worked after that time, and you'll find that change on 139, line 139. Through you, Madam President.
Senator Sampson.
Thank you very much for that answer, through you, Madam President. But I was under the impression that amount was changed back to the current amount of 40 in the amendment. Am I incorrect about that? And it is as the bill has is in the underlying bill before us, which is 1 in 30. And I certainly will take your word for it. I know that you're the proponent of this bill, and I'm just trying to understand. Through you, Madam President.
Senator Kushner.
Through you, Madam President, and I understand the confusion because it probably comes from as a result of the fact that in the past you accrued 1 hour for every 40 hours worked to a maximum of 40 hours. In this amendment, the bill is being changed with regard to the rate of accrual, but not to the maximum hours accrued, which is the 40 hours. So in other words, you accrue 1 hour for every 30 hours worked up to the maximum of 40 hours, and that is where the change is put forward in the amendment. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. I appreciate that clarification. And looking at the amendment, and if anyone happens to have the opportunity or desire to look it up online, you'll see that sometimes it can be extremely difficult to determine exactly what's happening when you're, striking a few words in a sentence and adding another word and that kind of thing. To track it against the original proposal can be difficult. And I was mistaking the 40 that is in the total accrued amount maximum for the 40 in how often you do accrue. And if anyone can follow that, God bless you for being very attentive. So I'm glad we clarified it, that this bill does change not only who it applies to, but it also increases the rate at which an employee will accrue their benefits from 1 hour for every 40 hours worked under current law to 1 hour for every 30 hours worked. And I just want to confirm that that is indeed correct. Through you, Madam President.
Senator Kushner.
Through you, Madam President, that is correct. Thank you.
Senator Sampson.
Thank you. And the next change that is indicated is the total amount of accrued paid sick days that an employee can earn. And am I correct that the current law is 80 hours, or is the current law rather 40 hours? The proposed bill said 80, and we are back to 40. Is that correct? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, that is correct.
Senator Sampson.
Thank you very much. I appreciate that. I wish the person who had drafted this amendment just struck that sentence rather than trying to change it back. It might have made it easier for me to understand, but I do get it. So we are making no change to the total amount that could be accrued. I think the next thing I just wanted to ask about was the ability to carry over paid sick time, and I think that's addressed also at the end of Section 2. And I think it's current law that says each employee shall be entitled to carry over up to 40 unused hours that are accrued of paid sick leave from the current year to the following year. Is that correct and will remain the same through you, Madam President?
Senator Kushner.
Through you, Madam President, that is correct.
Senator Sampson.
Thank you very, very much. And I just want to move on to closer to the end of that section. I'm looking at all of the new underlying language that starts on line 187. And I just have a few questions about how all this works, because it's a little bit confusing for me. In lines 187 through 192, it talks about employees that are exempt from overtime requirements. I'm assuming salaried employees. And it says that they are going to earn paid sick leave based on their normal work week. And I'm just curious, how does that work? Because I have worked a salaried job before in sales, insurance in particular, and no one really tracked my hours, and I was given a relatively modest salary plus commission. So I'm just curious how that works. Would somebody who works in a type of business that is based on a small salary plus commission, first off, be eligible to earn paid sick time? And what would the amount of paid sick time be measured against? Would it be measured against the salary or the salary plus the commission? And what if it varies week to week and sometimes dramatically? How does a calculation like that work? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. I believe that where someone is considered a full-time worker, that the amount of time that one would accrue would be considered, you would be considered having worked 40 hours, understanding that it could be a few hours less or a few hours more, but the employer is basically hiring someone for full-time work. You assume that that is a standard of 40 hours. If someone is working part-time on a salary basis, that could vary from week to week, but they would look at what was the person's normal work week. And when the person, I think later in the bill, you'll see reference to when the person actually uses the sick leave, it is pegged for a part-timer to the amount of hours they worked in the week previously. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. I find this paragraph troubling for a lot of reasons. I just gave one very, very simple example, but I can think of thousands more situations that really just can't fall into this paragraph neatly. And I want to remind everyone what's going on here, which is the state of Connecticut is going to pass a law that is telling an employer, you must offer this benefit to your employee under the penalty of law. You've also got to keep track of the hours of your employees. You have to measure and track and log and document the hours they've worked and the hours that they have accrued and so on under penalty of law. And we're going to get to the penalty phase of this bill at some point down the road in our conversation. But look at what we're doing. We are telling someone that they've got to keep track of something that, A, I think we can agree won't be easy to track, and B, might be impossible because people do vary dramatically. And I also brought up the notion of someone who is on a commission basis. There are people that work on nothing but commission. They don't make any other type of salary, even though they might actually be required to be employees because they've got to be in-house sales, for example, maybe car salesman or insurance, something like that. I'm wondering how this bill calculates the earning of accrued paid sick days for someone who is a commission salesperson. Through you, Madam President.
Senator Kushner.
Through you, Madam President, I can confirm that this bill does not change how commissions are handled, that if they were in the past included in any compensation that was built into a paid sick time, that has not changed. So it would not now include something that wasn't previously included. Through you, Madam President.
Senator Sampson.
Well, I can appreciate that, although I think that this paragraph begins to capture people that were not included before, because we're talking about people that are not working a regular work week, and that is someone that would fall into a commission basis. You know, we're talking about time off in one respect, but there is an aspect of this bill that says if you leave employment, the employer has got to have kept track of your time there and also has to pay you for it. So we're putting an employer in a very provocative position here where they may not be able to legitimately determine what the appropriate normal work week is or how much they should be considering is earned paid time off based on the method that they're paid. And people, I will remind the chairwoman and everybody else in this room, are paid lots and lots of different ways. You know, not everyone works on an hourly wage. Not everyone works the same work week all the time. There are people that travel for work. There are people that work several weeks out of a month and not other weeks. There are people that work at multiple different jobs. There are people that have flexible schedules. There are people that work on commission. There are people that work on tips. You can go on and on about all the different ways that people work and are compensated. And this bill is written by people who don't even have that understanding. It is way too simplified because the people that are writing this bill are just arbitrarily using their will to press a policy on people who didn't ask for it. They should at least have the consideration of understanding that there are different circumstances that people operate under and try and make it simple for them to comply with the law. A better idea would to not have a law like this to begin with. I'm going to just take a little aside before we continue on the bill, since I'm thinking about this right now, and that is just the notion of what a paid sick days mandate is. It's like almost every other thing that we see the majority come up with as a labor employer versus employee policy. It seems like almost all of them come from the same direction, which is to suggest that somehow employers are taking advantage of their employees and therefore we need the state of Connecticut, we need the majority party to interject themselves and come up with a solution to that problem of those evil employers taking advantage of their employees. I want to remind everyone in this chamber something that I probably have said in the committee. I don't know if I've ever said it here in the circle, but that is that the vast majority of employer-employee relationships are mutually positive. And the fact of the matter is, they are negotiated on equal terms. I hear people say that, you know, the employer has such a distinct advantage. I don't think that's true. They sit across from one another and they make a determination about what the pay and the benefit is. And yes, the employer's in the position of offering the job, and they do have that advantage. But the employee holds every other card. That business does not exist without employees. It can't function unless people are coming there to work. So that employer has got to respond to the marketplace and offer competitive wages. If they don't offer competitive wages, then no one's going to take the job. So who really holds the power? And the fact of the matter is that when this body decides it's going to come along and do things to unweight this, or to put weight on the scale, it's wrong. It would be just as wrong if there was weight added to the scale to benefit the employer. Everything that is done that alters the freedom in that relationship. And that's what kind of relationship it is. It's a freedom-based relationship. It is the personal choice of both parties to enter into it. This is not their personal choice. If an employer and employee negotiate paid sick time as part of the agreement, that's a beautiful thing. But when the government comes along and says that one party has to do X and the other party doesn't, or we're going to require a benefit from one side of that equation, what you're doing is you're limiting the freedom of both of those parties to come up with their own terms. That's the core reason why this is wrong, and it flies in the face of what our country's founding strove for, which is to give people absolute freedom to pursue their own endeavors. We're taking that away with every new policy. And the reason why these things are offered is because there's a political party that's interested in trying to sell the idea that they're trying to benefit certain factions of our society. That by itself is an extremely dangerous proposition. When you have people that are in positions of power making laws, doing it to benefit one group of people at the expense of another, you are down a dangerous path. And sadly, that is almost every day in this chamber. We have got to get back to recognize that we represent all of our constituents and that policies that are made need to apply to everyone across the board equally. Not this benefits this group or benefits that group. I serve on the Housing Committee as well, and the Housing Committee is all about, it's a battle between the landlords and the tenants. I have never looked at a single policy as a battle between the landlords and tenants. I ask myself, is this good policy for anyone? Does this hurt one group to the benefit of the other? Then if the answer is yes, the bill is bad. Does this policy benefit one group to the benefit of another? Or to the detriment of one and to the benefit of the other? Yes. Therefore, it's bad. It's just that simple. Let's go on to the next paragraph, which I find even more puzzling than the one before it. This is lines 193 to 197. It says, if an employee is transferred by an employer to another division, it's really the next paragraph that I find so remarkable. Well, let's talk about this one just for a second. This says that if an employee is transferred by an employer to another division, entity, or work site, but remains employed by that employer, they retain their paid sick leave accrued or received. And I've got no issue with that, although I think it doesn't take into consideration all of the different things that could be going on. You know, there could be a relocation going on. There could be a different way that a particular employee is going to be compensated because of this transfer. They might be going from a office salaried position or an hourly position to a pure commission position in the same company. I don't know that this bill really looks at the way things work in the real world and accommodates those differences. But let's do the next paragraph, because that's the one that really got me. It starts on 198, goes to 202, and it says, if another employer, okay, now we're getting into not just the employee and employer affected by this bill. We're talking about totally other people now. If another employer succeeds or takes the place of an existing employer, each employee of the original employer who remains employed shall retain the sick leave. Through you, Madam President, can you tell me what it means to succeed or takes the place of an existing employer? Who's included in that term? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, the word succeed has a legal meaning and is common in all kinds of statutes, but simply put, it generally refers to a company that buys another company. So it's the new owner of a company that was an existing business. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. And I appreciate that answer as far as the term succeeds. But the bill says if another employer succeeds or takes the place of. So what is takes the place of? Through you, Madam President.
Senator Kushner.
Through you, Madam President, I believe that adding takes the place of would also address a situation where the replacement of one employer by another might not be as a successor employer, but it could be another relationship that isn't covered by the word succeed. So in order to be clear, it adds the term takes the place of. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. Yeah, I've never seen this before in any bill that we've had, certainly when it comes to employers that versus the notion of succeeding another employer, which would be a business transaction where someone owns a business and sells the entire business to that other person, taking on their employees, taking on their assets and liabilities, taking on the business as a whole. Now we're getting into a whole new territory of takes the place of. So does this mean that if I own an insurance office, for example, and I sell it to some other person and they take over my insurance business and all of the employees and all that, that would be considered a succession, if I'm correct. Is that correct through you, Madam President?
Senator Kushner.
Through you, Madam President, that is my understanding.
Senator Sampson.
Thank you, Madam President. I appreciate that answer. But now let me ask you this. What if the purchase is not of the business? What if it was ABC Insurance and I buy only the customers from that company? I start my own corporation. I've got nothing to do with ABC Insurance at all. In fact, ABC Insurance might still exist. ABC Insurance might have other branches someplace else. But I'm just buying the policyholders, the client list from ABC Insurance, and I'm going to start XYZ Insurance, and I put up a sign there. Does that mean that if I decide to hire one of those employees, not in the case of a succession, but just simply because they're an experienced person in that industry, that I've got to adopt the accrued paid sick leave liability from the previous employer? Is that true through you, Madam President?
Senator Kushner.
Through you, Madam President, that is the case.
Senator Sampson.
Thank you, Madam President. I'll just simply state that that's madness. It's crazy to suggest that somehow someone who buys the mere assets of a business now is responsible for having to pay a liability that is owed by another company. It doesn't even make sense. Let me ask you a further question. What if I'm not opening XYZ Insurance? Maybe I'm opening Rob's Pizza Shop. So I go and I talk to the guy at ABC, and I decide to buy his storefront or buy out his lease or buy the building, and I move in there and open a pizza shop. But one of the people that worked there, maybe just the person who worked at the front desk of the insurance office, I said, "Hey, do you want to answer the phones at the pizza place and take orders, or do you want to make pizzas?" And they say yes. Am I captured by takes the place of? Do I have to, if I want to hire this person, be responsible for an amount that they accrued to ABC Insurance? Is that true, through you, Madam President?
Senator Kushner.
Through you, Madam President, I don't believe I can answer hypotheticals. I can only refer back to the legislation and what it proposes, which is if the employer, another employer succeeds or take the place of an existing employer, each employee of the original employer who remains employed by such other successor employer shall retain and may use all unused sick leave accrual. So I think that the language of the bill is clear, and I believe that I can't respond to hypotheticals, but I believe it will be very possible for a court of law to interpret the language if there's any question or doubt. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. I appreciate that non-answer. And I do think the language is clear, as you stated. And I think it does cover Rob's Pizza. I think it's pretty obvious if you read the letter of the text here. I would also suggest that part of the reason why we have this debate is to clear up a question like this and create legislative intent so that a court of law might look at us and say, well, what did the people that wrote this bill want to happen? So I think it's wrong to suggest that we can't answer hypotheticals. And I'm dismayed, actually, that we're not going to get an answer for that question that's concrete. But I'll answer it, and I'll make it very clear that my reading of the bill says that that new employer would be responsible. And I think that's just crazy. That is a major defect in this policy, and it shouldn't remain. And I would encourage my colleagues to find a way to take this out of the bill before it becomes the law, whether it has to change in the House and come back here or whatever it is. But to me, that's unacceptable. There's no reason to put a policy provision like that in a law that we're going to impose on unknowing citizens of this state. Because I guarantee you, both ABC Insurance and Rob's Pizza got no idea about this when it happens to them. And they end up before the labor commissioner having to explain why they refuse to pay something that they don't feel that they owe legitimately. Moving on, there was, at the end of Section 2, there was a paragraph here about the Personal Care Attendant Workforce Council, but that is now removed in the amendment, and I'd like to just confirm that is the case and that there is no mention of the Personal Care Attendant Workforce Council or any effect this policy has on that group that wouldn't affect everyone else in the state as a result of the amendment that has just been adopted. Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, that is correct.
Senator Sampson.
Thank you very much. That was something that raised certain red flags for me in the committee, and I do appreciate the effort that was made to remove that part of the bill that's before us. Just moving on to Section 3. Section 3 has to do with the reasons that an employee can use to obtain the benefit of the paid sick leave that's been accrued. And as was discussed briefly, we talked about family members and that sort of thing. So according to this bill, starting on line 225 through 231, it looks to me that an employee can use their paid sick days, obviously for their own illness, but also for a family member's illness, injury, or health condition, and also for an employee's family member for mental or physical health. Is that correct, through you, Madam President?
Senator Kushner.
Through you, Madam President, that is correct.
Senator Sampson.
And moving on, in lines 232 through 240, this looks to be how such illness might be documented. If an employee says, I need a mental health day, so I'm taking off on Friday, do they need any documentation to provide to their employer, Madam President?
Senator Kushner.
Through you, Madam President, I may have misheard, but I thought you were referring to starting on line 232. Did I misunderstand what you were saying?
Senator Sampson.
Yeah, my question actually relates to the entirety of Section 3. It's just the conversation about the reasons for a paid time off might be usable, and how it's documented is contained in both 232 through 240, and then also some lines farther down, 261 through 267, I believe. But my question is simple. If I say to my boss, I need a mental health day, and I'm not going to be here on Friday, I know the big sale's coming, but I'm taking off on Friday, is that acceptable under this mandate through you, Madam President?
Senator Kushner.
Through you, Madam President, I do believe, starting on line 261, it does permit a person to take time off. They must provide a written statement from the employee stating the fact that they are taking paid sick in the purpose of that reason, the reason for taking the paid sick days. That's what's covered in that line. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. So what I'm hearing is that you don't necessarily need a note from a doctor or any other written documentation than just a statement from the employee themselves affirming that they're using their paid sick leave. And that is, quote unquote, line 265, shall be considered reasonable documentation. Is that correct? Through you, Madam President?
Senator Kushner.
Through you, Madam President, that is correct.
Senator Sampson.
Thank you very much, Madam President. I appreciate that answer. To me, I just, this is a very one-sided bill. This is the kind of message that I'm trying to get across to folks, which is that this is not being written in an attempt to develop good policy or to protect workers. This is simply being done as a mechanism to engender those who want to use government to alter what is otherwise a equal and voluntary agreement to the benefit of one side for political gain. The next sentence says, such written statement may be written in the employee's primary language and need not be notarized or in any particular format. I assume that means that if English is not your first language, you can write the note in another language and provide that to your employer, whether they speak that language or not.
Senator Kushner.
I didn't ask a question, Madam President.
Sorry, I thought you were pausing for a question.
Just reading on within the bill. Thank you. I'm now at the end of Section 3, and I note that there's a sentence in here that says an employer may not require an employee to provide any documentation to explain the nature of illness or the details of the family violence or sexual assault, if that's the reason. And I'm certainly sympathetic, obviously, to someone that has experienced a traumatic event like that. But to suggest that an employer doesn't have a right to have documentation for when someone's absent from work, I just, wouldn't that be something that rightfully be left up to the employer and employee to determine what their relationship is? You know, if I go to work for a job and my boss says, look, Rob, you're going to work here, but I only have one person who works on Fridays. So you got to do me, you got to make sure that you're here because I need you on Friday, and that's a critical part of your job. I need somebody who's reliable on Friday. That's maybe more important than any other aspect of your job. And this bill undermines that. This bill says that it doesn't matter what that agreement was between the employer and the employee, and the knowledge that was what they agreed to because that was what was a key ingredient in the terms of the employment. This body, if they vote for this bill and pass it into law, they say they don't care. We don't care what your voluntary free choice was. Instead, we're going to tell you. And we're going to also make it so your business is less successful because you can no longer say you're counting on somebody as a condition of employment that they are reliable on Fridays. As I mentioned numerous times before, it's a free agreement between both parties. They should set the terms. Okay. Moving on. I know this is existing law, but it's something I meant to ask. And it's relevant because it does say as amended by this act. But lines 341 through 344, it says that an employee aggrieved by a violation may file a complaint with the labor commissioner, and that makes perfect sense. But then it says, upon receipt of any such complaint, said commissioner may hold a hearing. And since this is the current law, I'm curious if we have any information or data to say how often does a commissioner hold a hearing, and what is the criteria that determines whether they should or not? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Can you give me one moment?
The chamber will stand at ease briefly. Senator Kushner.
Thank you, Madam President. I am seeking that information, and we can proceed with another question, and when I get it, I'm happy to come back to it. Thank you.
Senator Sampson.
Thank you, Madam President. I really don't have any other questions. I do want to wrap up on the bill, but I was hoping to have that answer because I may have some follow-up questions. And it doesn't seem to be too difficult a question. First, maybe the second part of my question, maybe we have an answer to that, which is, upon receipt of any such complaint, said commissioner may hold a hearing. And I guess I would ask, to simplify it, is the commissioner required to hold a hearing, or are we simply telling the commissioner that they can arbitrarily decide which businesses they want to require a hearing from and which businesses they don't want to require a hearing of, and we are not giving them any guidance? Because that's what I'm reading. Through you, Madam President.
Senator Kushner.
Thank you, Madam President. I believe that when it says may, you're not required to hold a hearing, that the commissioner is allowed to hold a hearing. But I know from my experience with the Department of Labor and other statutory relationships, they also have this language where they may hold a hearing, and typically the Department of Labor seeks to resolve disputes without going to a hearing, and that most frequently occurs when an employer isn't aware of their statutory obligations. When they're made aware of it, obviously, most frequently the employer fixes the problem. But if they were not to, then the commissioner of the Department of Labor would have the authority, based on this statutory language, to hold a hearing. And I believe, as you pointed out, this is underlying law and has been in existence. Thank you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the answer. I thought it was valuable to ask the question simply because the paid sick days policy has been in place, as was mentioned, for over a decade now. And I would assume before expanding that program exponentially, as we said, going from 12% of employees in the state to close to 100% of employees, we would not only know how many employees that is, we might also know how many hearings there've been, or what those hearings have been about, or what the criteria is for when the commissioner is actually going to hold a hearing with an employer. And it concerns me that we are not establishing a set of criteria and instead leaving an appointed partisan official to make decisions about how they want to proceed in these cases. We saw during COVID lots and lots of decisions that used to be made via the rule of law being transferred to different parties to make arbitrary decisions because they were in positions of authority. That's what they do in authoritarian countries, not in America. We operate by the rule of law. And when you write policy that says, the commissioner may hold a hearing, you're giving them tremendous discretion. And when you're dealing with controversial policy that falls on ideological lines, and you're empowering a partisan official to make choices, that should concern everyone in this room. I'm just going to wrap up. I think throughout the Q&A, it's kind of clear where I stand on this bill, which is that I don't like the paid sick days policy to begin with. And not because I don't believe employees deserve paid sick days or that it's bad for employers to offer paid sick days. Those are beautiful things. Paid sick days were invented without the government. Okay, the government did not have to come along and tell people, offer paid sick days to your employees. They did it already. And why did they do that? They did that because in a free marketplace, lots of things happen. Innovation, creativity, new ideas, and more production and quality of life. That's what happens. So businesses, in an effort to compete with one another, they came up with inventive ways to offer new things to entice people to come work for them. But I'm afraid that some in the majority believe that innovation is dangerous, that it's the state that should make all the rules about everything and decide what we should set our thermostats at home or whether we should have gas lawnmowers and what benefits we deserve and what we should give to our employees. And I don't believe any of that. I believe those are all decisions to be made by the people I work for, the people that elect me to go up there and protect their right to make those decisions on their own. And make no mistake, what is happening is every day that this place comes into session, at least as long as I've been here, I have watched and watched as that freedom to make choices on your own is diminished. It is diminished by policies like this, which are sold to the public as a benefit. We're going to look out for you. Well, you're not looking out for anyone when you're taking away the freedom of that person to be able to negotiate for themselves even something better. Our country was built on the notion that people are free, adult citizens who can make their own choices. They're not children. And in fact, they are our bosses. They tell us what to do. It is wrong for us to be writing policy that imposes our worldview on them. And this policy does all of that and more. Besides all of the ideological problems I have with this bill, the other issue is that it is going to effectively diminish the economic viability of Connecticut because it is just another requirement and regulation on businesses that, even if it doesn't impact the business directly because they already offer this benefit, sends a message to them that says that this Connecticut legislature is more than happy to make new rules for you anytime they feel like. And if I'm a business in Connecticut that's wondering whether I should stay or go, I'm watching what the legislature is doing. Is the legislature making more rules for me to make it harder for me to be here? Maybe the next one that comes a week or a year from now is the thing that breaks my business and puts me under. If I'm a business that is from out of state and I'm thinking of relocating and I love the idea of Connecticut, maybe I grew up here and moved away and now I want to bring my business back to Connecticut. I'm watching. I'm reading the trade magazines and figuring out what's going on. And you know what I'm learning? I'm learning Connecticut is at the bottom in anything that says bring your business here. It has a chilling effect in other words. If I was going to start expanding my business in Connecticut and taking on employees, now I'm pausing. I'm like, wait a second. They're going to make it even harder for me to bring employees into my business? That's opportunity lost. That's economic growth lost. Somewhere, I had a quote here from our governor just from a couple days ago, and I'll just paraphrase. He said, I cannot give more money to the nonprofits. I cannot expand the benefits of the state of Connecticut unless we have economic growth and opportunity. That's what he said, more or less. And he's right. He's saying, look, our economy has to be in good shape for the state to be financially able to provide all of the glorious benefits that he and the government want to offer. This policy says, stop in your tracks. The state of Connecticut is going to make more and more laws. It's just more interference. Death by 1,000 cuts. I don't encourage anyone to support this legislation. I do encourage businesses and people that are concerned about this type of policy to pay close attention and to let the people in this circle know what you feel and what you think and what would entice you to come to Connecticut, start a business and hire employees and offer nice benefits to those employees. I know what those things are. Those things are a set of policies that says we welcome you. We're not going to overregulate you. We're going to make it simple for you to open your business. We're going to entice you to want to hire people and pay them good wages. That's the type of policy we should be doing, not policy that impacts businesses in a negative light and is characterized as benefiting half of the equation in a business agreement. It doesn't benefit either party in the long run. And I'm sorry that more people don't understand that. We've got to get back to understanding that what made this country great was the freedom for people to come up with their own negotiations, their own creativity that resulted in the economic prosperity we have today. That's what I long for, Madam President. So I'll be a no today.
Thank you. Will you remark further?